Good afternoon.
Good afternoon, Judge.
All right. I've got in front of me join indispensable party. Hold on a second. I think I've still got to get our court reporter all the way in. Ms. Williams, we have you? Ms. Williams, can you hear us?
Yes, thank you. I can.
Okay, are you ready?
I am. Thank you.
Okay. All right, so we are here on defendant's motion to join indispensable party. I think the issues are clear to me. I have read the short briefing. Mr. Hawkins, tell me a little bit about the background of this case and factual circumstances. There was some small reference to it in your brief, but if you could just give me an idea of what this is about.
Sure, Judge. First of all, just to introduce myself, I'm Jack Hawkins. I do represent Meltzer Group in this matter. I want to thank you, Judge, for taking a little time today so that we can talk about the case. This case arises out of a shooting which occurred on February 2nd, 2019. I don't know if Your Honor remembers, but Atlanta hosted the Super Bowl a couple years ago, and this shooting occurred on the Saturday of Super Bowl weekend at a parking lot that is located over off of Farr Road and Grandview. I don't know if you're familiar with the area in Buckhead, but there is an area where my client is co-owner of several parcels of land over in that area that comprise 10 buildings bounded by various roads, and there's parking lots and whatnot. And the plaintiff had come to the parking lot because he was wanting his fiance to have her makeup done at a salon. And they were sort of in the process of getting out of the car when two armed assailants came up to their vehicle, made demands, give me your stuff, I think is the way they put it. And ultimately, one of the assailants shot the plaintiff, who was injured and now has filed this lawsuit to recover for damages relating to that incident. It's important to note that my client, Meltzer Group LLC, is a co-owner of the premises in question as a tenant in common with MAT Investments. And as a tenant in common, Judge, I don't know how often that term comes to your plate these days. I can tell you that I almost had to go back and pull up a horn book from my property days in law school to figure that out. But you may recall that it involves both entities have an undivided equal interest in the entirety of the property. And Meltzer Group and MAT Investments are tenants in common owners of the parking lot in which the plaintiff was shot. And so we have filed this motion on behalf of Meltzer Group, seeking to add MAT Investments as an indispensable party. Your Honor, I'm glad to go forward, or if you have any specific questions as background or whatnot, glad to address those before I go into argument.
You can go on to your argument.
Okay, great. Thank you, Judge. The plaintiff has only sued Meltzer Group, one entity, and in response to our motion to join MAT as an indispensable party, plaintiff has said, well, they're joint tortfeasors, so I can pick who to sue, and I picked one, and that's all there is to it, which is not exactly completely the case. In fact, Georgia case law does support the proposition that if there are joint tortfeasors, the plaintiff can pick one to sue and doesn't necessarily have to sue both. That's true. However, that is not inviolate. If indeed there's an occasion where the facts demonstrate that another party is an indispensable party, that party can be added pursuant to Rule 19 of the Civil Practice Act by the court upon motion of one of the parties. And it doesn't have to be the defendant moving, it doesn't have to be the plaintiff moving. It can be either one. Rule 19A, I know you're familiar with it, Judge, but it says that a person who's subject to service of process shall be joined in a party if, number one, in his absence, complete relief cannot be afforded among those who are already parties, or number two, he claims an interest relating to the subject of the action and is so situated that the disposition of the action may, and then it breaks it down into A and B, A, as a practical matter, impair or impede his ability to protect that interest, being the other party, the non-party, or B, leave those who are already parties to the lawsuit at a substantial risk of incurring double, multiple, or otherwise inconsistent obligations by reason of this claimed interest. The rule specifically allows the court to enter a party or to enter an order declaring the indispensable party to be a party. While I'm certainly not going to ascribe any motivation to plaintiff's counsel as to why plaintiff's counsel only sued one party as opposed to two, let me tell you a couple of the consequences that determination has and why it demonstrates that MAT is an indispensable party. I think first and foremost, if MAT is not added to these proceedings, plaintiff could file a separate action against MAT alone and could then obtain a double recovery or otherwise obtain an inconsistent result. For instance, if we were able in this case to get summary judgment in favor of Meltzer Group, they could then turn around and sue MAT in Superior Court, get a different judge, make different arguments, and get essentially a whole nother fulsome bite at the apple. Or if for some reason they were to get a verdict in this case, but decided that wasn't enough, they could sue MAT. When they did that, MAT then would have a right of contribution in theory against Meltzer Group. So Meltzer Group cannot be afforded its full measure of relief by the adjudication of the dispute between the current parties to this litigation. And so that is one consequence. Of course, another consequence of only suing one entity, and I would submit this is probably the countervailing consequence that led to the result, is that Your Honor is probably familiar with the recent holding by the Georgia Supreme Court in interpreting the apportionment statute to say that if only one defendant has been sued, you cannot apportion liability to non-parties. And here, of course, those non-parties would be the two armed assailants who shot and robbed plaintiff. The jury would not be able to apportion any liability to them if only one defendant was involved in the suit, at least according to the law as the Supreme Court has recently announced it. As you know, it seems these days the law is always subject to change, but as of now, that would be the case. Again, MAT is clearly an indispensable party. It's got an identical interest in Meltzer in the ownership and operation of the party or of the property. Last week, the person who was responsible for managing the property provided deposition, which Mr. Campbell took, and he testified that he actually got paid by MAT. So the person managing the property is paid by MAT. So MAT, again, indispensable to these proceedings. Now, the concept of Rule 19, Judge, is the idea of just avoiding these repetitive lawsuits because the law deems it desirable to go ahead and get everything sort of taken care of in one lawsuit. And the Supreme Court has specifically noted that that relates to all claims which derive from personal injuries sustained by a single individual, which is what we have here. Now, again, the two standards are either that the person, and either one of the two standards can be met. It's not a situation, it's not an and, it's an or. The first one found in Rule 19A is a person should be joined if complete absence cannot be afforded among those who are already parties. And like I said, Judge, Meltzer cannot obtain complete relief here because its co-owner is not a party and potentially could be subject to subsequent suit, thereby allowing it to then file a contribution claim. Again, all of this is arising out of the exact same incident involving injuries to the exact same person. So as the Court of Appeals said in somewhat interpreting the Supreme Court's rulings, the idea is to eliminate the need for the same accident case to be tried twice with possibly different results. The idea is let's get it all taken care of in one lawsuit. The second standard, Judge, is that if either the party claims an interest, in other words, MAT claims an interest, that its interest could be impeded as a practical matter, or alternative, and I've already discussed how that might happen, or there may be otherwise inconsistent results from two separate pieces of litigation. Again, we've talked about that. Judge, we would submit that MAT is an indispensable party given its equal, undivided, and identical interest in the property, and that Meltzer's interest would be impaired if MAT was not brought in, because it could be potentially face a situation where MAT is later sued. And I would note, Judge, that of the two assailants, one has been arrested and has pled guilty. The other assailant is yet to be caught and brought to justice. So as plaintiff indicated in their complaint, statute of limitations has been told during the pendency of criminal charges against the assailants, and that remains. And so to this day, I believe they would still have at least an additional 2 years to bring suit against MAT, perhaps longer if the assailant remains at large and is not adjudicated on those criminal charges. So, Your Honor, finally, I would just note OCGA Section 9-1121, Rule 21 of the Civil Practice Act also allows the court discretion to add a party at any stage of the action on terms as are just. Even if the court were to find that somehow MAT is not an indispensable party, which we believe MAT is, given the identical interest, then the court would still have the discretion to add MAT so that all of these claims could be adjudicated in a single lawsuit. With that, Judge, if you have any questions, I'm glad to address them.
No additional questions.
All right. Thank you, Judge.
All right, Mr. Campbell.
Thank you, Judge. Good afternoon. I appreciate the court first accommodating the conflict I had this morning with another hearing. What are the chances the two hearings get set at the same time that they did? I certainly appreciate both Jack's accommodation and the court's accommodation so that I could be at both. I'll start by saying I have tremendous respect for Jack. I know he's an excellent lawyer, and I think he's done an admirable job in this case of complicating an issue that is not complicated if you look at the applicable case law. And the reason why I say that, Judge, is we heard about the tenant in common issue, and I'm with Jack on this one. I recall that term, but I don't do any property law. I only do tort law, so I'm not up to speed on all of the duties as it relates to tenants in common in a property case, but this isn't a property case, Judge. And that's what's important. This is a tort case. And so the fact that they have equal interest, as Jack describes it, makes them joint tortfeasors. So then the question becomes, if they're joint tortfeasors, what does the law treat joint tortfeasors as indispensable parties? And fortunately, we have direct on-point appellate case law, the Ford v. Olympia Skate Center case that we cite in our brief, that says specifically, joint tortfeasors are not indispensable parties in an action against one of them because their liability is both joint and several. So ultimately, Judge, the joint tortfeasors are not indispensable parties. The case law goes even further to make it clear that when we're talking about joint tortfeasors, 9-11-19, the rule that Jack has been talking about in the application and the factors considered, has no application. If we look at the Georgia Department of Revenue v. Moore case that we cite in our brief, it says under Georgia law where the complainant has the right of election as to which defendants he will proceed against, OCGA 9-11-19A has no application. And that's essentially where we're at, Judge, is the law, and I certainly appreciate Jack's arguments as to why the defense would prefer the law be different. And I would probably be making similar arguments if I was in his shoes. But the reality is, Judge, the law is clear that joint tortfeasors are not indispensable parties. And that the plaintiff, when they have the right of election of which joint tortfeasors to sue, they may do so. Goes on, if we look at the North Carolina Bank, the People's Bank of LaGrange case that we cite, it is for the plaintiff to say whether he wants to sue other defendants. Joinder is at the option of the plaintiff. It cannot be demanded as a matter of right by the defendant. And that's what we have here. Plaintiff has sued an entity that has an ownership interest in the property. As Jack said, we learned a little bit more this past week. We took some of our first depositions in the case, and there was the individual who was the property manager out there said, I think I work for Meltzer. My check said MAT, but that's all I ever heard of MAT. Meltzer Group is who I think I work for. And the reality was there was no differentiation in their operations as to who was what. There was one entity out there. All of the leases said Meltzer Group to the tenants, but it's really of no consequence, Judge, because what we have is they're undeniably joint tortfeasors. And Georgia law provides that joint tortfeasors are not indispensable parties. And while they can be joined, the joinder is at the election of the plaintiff. And in this case, Judge, we've elected not to add them to this case.
I
Good.
need to consider ultimately whether complete relief can be afforded without the presence of additional parties. And I have some concerns. And so I need to ask you, should I consider, or am I allowed to consider the effect on this case of an inability to apportion to non-parties? You know, because in our previous life, and I think everything leading up to the Hatcher decision, everybody was predicting, well, of course, there's going to be apportionment with a sole defendant. But that didn't happen. So that means that even if Mr. Hawkins decides, well, I'm going to file a notice of non-party fault, or and try and get the jury to apportion some portion of fault either to my co-owner or especially to the criminal alleged perpetrators, then the jury might do that. And the jury could do 0, as we know, but the jury could do 100%. Isn't that a prejudice?
And Judge, I would say it's certainly a negative consequence for the defense, no doubt. But Judge, what I would say in response to that, as Hatcher lays out, it's for the defense is not entitled to this idea of non-party apportionment absent the legislature empowering them with that. As the Supreme Court said in Hatcher, the Hatcher decision, the legislature did not authorize in single defendant cases for this non-party apportionment. And so while the court is correct that a negative consequence of this being a single defendant case is that they won't be able to apportion the non-parties, that's not that's a consequence of the law as drafted by the legislature and interpreted by the appellate courts. What the court is not authorized to do is to try to get to the result of, well, we think they should be able to apportion and that the Hatcher is wrong or the legislature got it wrong or whatever the consequence was that led to that. We can't otherwise treat parties that aren't indispensable as indispensable for purposes of allowing them to have a non-party apportionment right that the legislature simply, based on the court's interpretations, did not draft into the statute. And it's not for us to I expect we're going to be hearing a lot in the coming legislative session about that potentially, and there will be some litigation down the road about that. I certainly believe that we have not heard the end of that, but I think as things sit, Judge, the law is in a single defendant case, they don't get to apportion. The question before the court here is this a single defendant case, or can the defense force it to be a multi-defendant case? And I don't blame Jack for giving it a try. And I think we'll see lots of parties trying it in similar circumstances. But the reality is the case law is clear. Joint tortfeasors are not indispensable parties. And so a defendant cannot end around the Hatcher decision by trying to require a defendant to sue multiple entities and make it a multi-defendant case.
Your Honor, if I may just briefly just make a few points. It's interesting. Your Honor notes the, shall we say, unexpected nature of the ruling in Hatcher by the Supreme Court. Scott and I have been involved in this case, obviously, since before the lawsuit was filed. And I had a conversation with the client before Hatcher came down, explaining the decision that the Court of Appeals had made, which was similar to the Hatcher decision. And I said, let me tell you how ridiculous that ruling is. I have a case right now involving 2 co-owners who are tenants in common. They literally have the exact same interest in the property. Clearly, one would be an indispensable party to the other. But the Supreme Court has now said that if one of those is sued, but the other is not, that you could not apportion non-parties, but because they are indispensable parties, they would have to both be sued. And therefore, simply because of the happenstance that there are 2 co-owners to this property, apportionment would apply. That I said is part of the reason the Supreme Court will see around this and will rule against and reverse the Court of Appeals. Judge, as you might imagine, there's a good reason I don't gamble, because I apparently do not do well at reading the tea leaves. And I was wrong, absolutely wrong on that. But I'm absolutely right on the indispensable party issue. I think it's interesting that the plaintiff has cited the Ford versus Olympia Skate Center case that Mr. Campbell just referenced. That involved a plaintiff who named the wrong corporate entity and then tried to get another entity brought back in after the statute had run. The Court of Appeals didn't even address Rule 19 there. That was a decision under Rule 15, which talks about permissive joinder and amendment of complaint. Mr. Campbell also mentioned the Georgia Department of Revenue case. Well, that was a case involving entitlement to a refund from the Georgia Department of Revenue. And it was interesting because the holding there was, well, if the plaintiff gets to choose who to sue, then the Rule 19 doesn't apply. Well, yeah, that's true, because the plaintiff gets to sue who they want unless they omit indispensable parties. There's a whole reason that we have Rule 19 there. And so that circular reasoning, frankly, just doesn't apply to this case. Now, the recitation to the North Carolina National Bank case, I think, is particularly interesting because there the court specifically said, you know, we're going to disallow the joinder as an indispensable party because it's not like they've shown that the defendants have a joint interest in anything involving the case. Well, here there's indisputably a joint interest in the premises in question, and any adjudication here as to Meltzer in relation to these premises clearly affects MAT and vice versa. If the plaintiff was not required to bring in MAT to this litigation, MAT could then be sued, could sue Meltzer. So Meltzer wouldn't be afforded complete relief. Again, Rule 19, the entire point of Rule 19 is to get complete relief afforded amongst the parties to the litigation. And we respectfully submit MAT is an indispensable party and should be added to this litigation as a party defendant.
All right.
I'm
Mr.
sorry, Lynn.
I'm sorry, Miss. I'm sorry.
Okay. Which one thing, Judge, on that last statement, it's complete. If we're talking about complete relief among the parties, it's among the parties. You don't have to look, are there other entities out there that could potentially not be impacted by it? It's complete relief among the parties. And what the Court of Appeals has said is joint tortfeasors, a plaintiff can pick which tortfeasor they want to sue, and that the jointly liable tortfeasor can't force the plaintiff to add other parties. That's what we have here. And I think the appellate precedent on that point, Judge, is pretty clear.
All right. I think when I look at the statute 9/11/19, I look specifically at 9/11/19 subsection A to capital B. I think that applies in this case. I think that the defendant is at risk of double, multiple, or otherwise inconsistent obligations. And I also think that under 9/11/19B, looking at the factors considered by the court, that a judgment here rendered in the absence of the finder of fact being able to consider the fault of all parties simply by reason of it being a single defendant versus a double defendant, I think is prejudicial. I understand the statute as written doesn't specifically allow the jury to do it, but I don't think that prevents me from using my discretion to allow at least the possibility that the jury consider the fault of non-parties or all parties who may be liable in this situation. I believe the public policy addressed by the apportionment statute is to have everyone who could be found at fault at least in the jury's consideration. If that's what one of the parties wants, to have a fair opportunity to say, hey, it's not my fault, it's this person's fault. I recognize there that this is first impression and that the appellate courts may not agree. And we may wind up coming back here with a different decision. But that is my ruling. I think that's the fairest way to proceed under the circumstances. So I am going to grant the motion. Council, you may want to consider, you may have already considered whether you want a certificate of immediate review on this. I don't know if this qualifies with something for immediate review or if Mr. Hawkins would have any objection, but I'm at least willing to consider the possibility.
And I appreciate that suggestion, Judge. I will be frank, I do not mean this in a, with any disrespect to this. Frankly, I hadn't given any consideration because I thought the law was pretty clear that they could not force the adding of this. I will give some thought to that now that I see the court is going to rule otherwise. Obviously, the last thing I want to do is try the case, get a result, and then have to retry it. On the plaintiff's end, that's obviously the thing we always want to avoid, or I say all sides generally want to avoid that, certainly the court does. So I'll give some thought to that. The only thing I would say, Judge, in response is I do think there's a footnote in Hatcher that touches on this idea, where the Court of Appeals essentially said that they're not left without a recourse, the party that can't apportion it. There's other things they can do to recourse that. And I think what the Hatcher court says is that's the means by which, because the apportionment statute doesn't provide for it, that they can be afforded complete relief. And I don't want to re-argue the point, Judge, but I just in response to the court's comment on that, but I'll give some thought to it. I mean, frankly, I don't think it benefits anyone to litigate the case in a way that has that built in without us having some clarity. So it might make sense. I'll talk with Jack about that and see if we want to go ahead and do that. I mean, I think it's certainly something that I appreciate you flagging, and something I'll give some consideration to and communicate with Jack and then report back to the court on.
Mr. Hawkins, any initial impressions that, or you want to hold on to that until you've had a time to think about it and talk with your client?
Judge, as it relates to a certificate of immediate review, I think my interest would be similar to that expressed by Mr. Campbell, and that is, I don't want to try the case and then have to retry it. If down the road we end up determining that perhaps a different ruling should have been made, but more importantly, if indeed this party is in the case, then the case will go in a different, I'm not going to say a different direction, but there will be two defendants, and obviously the tenor of the case will be different in terms of discovery and in various other issues. So, I think that is somewhat of a threshold issue that should be, if plaintiff really feels like they need to appeal that issue. Again, I guess as confident as Mr. Campbell was, I was similarly confident the other way in that, I mean, if there was ever an indispensable party, a joint co-owner would seem to be that. But nonetheless, I will certainly confer with my client as to whether we would lob any objection to a certificate of immediate review. But at this point, I won't say we don't have an objection, and I won't say that we do. How's that for saying absolutely nothing in 5 minutes?
I think it's clear what you think, what you personally think is the most efficient way, but obviously you're beholden to your client and have to be on the same page with your client. So I understand that completely.
Sure.
Mr. Hawkins, if you would submit a proposed order, run it by Mr. Campbell first, see if y'all can at least agree on the form, especially if it's an order that's going to go up interlocutory. You need to make sure that everything's buttoned up so that the issues are addressed squarely, the issues that we want to address before the Court of Appeals are squarely in view. And, once you have Mr. Campbell sign off as the form, we'll take a look at it and go ahead and enter.
Should I send that to Ms. Townsend, Judge?
Yeah, Mr. Townsend will take it and look at it.
Okay, great. All right. Thank you, Judge.
All right. Thank you, Mr. Campbell. Mr.
Thank you,
Hawkins.
Judge.
Thank you,
Yeah.
Judge.
Rest of the day.
Thanks, you too.